Hey, and welcome to All Things Social Security. My name is Stephanie Joy of Joy Disability, and you're about to see a piece of what goes on with our Wednesday live Q&A session. It's a live stream on this channel every Wednesday at 1 p.m. Eastern Standard Time. It gives you an opportunity to ask questions and have them addressed on the spot on a first come, first served basis. Otherwise, I also want to welcome you to the channel generally. We have our 12 noon newer time frame, that is, shares of video tips and goings on that occur in the midst of any workday on Social Security and SSI matters, as well as beneficiary matters and other things that go on in our workday that we feel often helps claimants who are pro se and or have a representative, but it's just some information they want to get a better grasp on. So we share them here every day, and I welcome you to join us every day at noon. Thank you so much. Have a great day. Ivy says, hi, if an applicant for SSDI was to be approved before the 5th month waiting period, how much does the attorney would get paid? A percentage of the first check? Or no. The contingent fee agreement produced 0 back benefits. The attorney gets 0 from the contingent fee agreement. Now, what there is a secondary avenue to try to get a fee approval of some amount, and that's the fee petition amount. That means he or she has to itemize all the work done, submit it on the fee petition form, which I believe is the 1560. If you guys need it, I think it's HA 1560, or it could be SSA 1560. I don't recall. It's been a long time. We don't get fee petitions very often that we do here. And then if that's the case, then he will go to you to try to get you to get on a payment plan or otherwise pay him. So it is not an ideal place for an attorney. It's usually, for us, it's usually, unless the person's loaded and they're honorable and they want to pay, a $5,000, we'd come to some agreement on the amount and say, let's do a fee petition for this amount. And they can pay it. And that's some people that have done that in the past. They definitely want to pay. They don't feel like it's right to not have to. However, it is something that the attorneys often have to eat. And this is when I did a recent video, some of you may have seen, about the people that complain, the few people that occasionally voice opposition to paying a $9,200 fee when their perception is the attorney didn't work enough to do the $9,200. You got to realize that's the nature of the beast with contingent fee agreements. You get to pay nothing for all the work if you don't prevail, or if you prevail and there's no back benefits, so you win your benefits, but the attorney gets, So, but for you, Ivy, the contingent fee agreement will not pay him anything. There's nothing about first check that doesn't apply. So he or she will presumably have to do a fee petition, or he or she's going to do what sometimes we do, is just chalk it up to goodwill and say, I'm not doing the fee petition. Don't want to see you with the bill. This is particularly true if I have people with they're not wealthy people to begin with, and they have low disability amount. They're not the $4,000 a month person. I'll just waive the fee and I'll eat it, because I don't want to see somebody have a stress over a bill, even if they're on a payment plan with us. It just would ruin the whole thing for me from a psychological point of view. At least half of my positivity out of this field is that that's what doesn't happen, is billing people. So I prefer, generally speaking, to waive the bill and wish everyone good luck and keep me in your prayers type of thing. And it's all good. So, but every lawyer is different. Most will probably do a fee petition, I'm guessing. And in the earlier days, I probably did too, because you had to. But I feel that I'm in a different place now, and I don't necessarily have to do that. Hey there. That was one of our little Q&A clips. I hope you found it informative or helpful or just enjoyable. I am attaching a related video that we have put together a while back that is on a similar topic and or an extension of what we were just talking about. So if you needed some more information on that, that's a place to start. You can also look in our playlists. There is a ton of them. I think there's over 1,000 videos. So there's almost every topic in the world touched upon in some way, shape, or form. And again, as a reminder, you can always put in the comments any kind of question you have, even if it's unrelated to this or any other video. I will talk to you later. Carry on. Good morning. Wanted to share some of the details about a fee petition. This is the alternative format for a representative who's been officially appointed and represented a person to completion and to prevailing. One of the two ways of asking the SSA to order a fee, prove a fee is actually the proper word. So, the first way of getting paid by a rep is through that contingent fee agreement you probably signed. That's the one most people are familiar with. 25% of back benefits capped at whatever the current legal cap is. As you may know, in 2024, at least up until November, end of November, at least, it is $7,200 as a cap. So even if you had $100,000 in back benefits, the representative would not get $25,000, they'd get $7,200. That amount is changing to, as I understand it, $9,200 by the end of November 2024. And if that sounds troublesome, it really shouldn't be, only because they went for far more than a decade without getting an increase in the cap, despite everybody else getting COLAs. So I think they're trying to change that and make everything always have a COLA. There are other things that don't have COLAs that should. This is one of them. So in the event that there is no back benefits, but you prevailed, and that can happen if the onset date that the SSA agrees you became disabled at was not the one that you asserted, and it was much later such that you might still be in at the time that they award you in that 5-month waiting period that applies to Social Security disability claims. That does not apply to SSI claims. So if there is no back benefits from which to derive a 25%, can't get 25% from zero, then people will file for under a fee agreement, the alternative. And that's where they itemize all the work done, times it by their billable hour, and that amount and the whole itemization is submitted to both the claimant to see and the SSA, who will decide what the fee is going to be. They don't necessarily go with what all the work was. And I wanted to go into what would they be considering, so you kind of know what they're looking at when they decide what to award or approve. Okay, so they tell us, and it's literally in the SSA-15 petition paperwork. So if you read the fine print, here's what it says. Evaluation of a petition for a fee. SSA determines a reasonable fee for the services provided on a claim, considering the purpose of the Social Security program and or Supplemental Security Income program. So it can apply to either of those programs. Number 1, the extent and type of service the representative performed. Number 2, the complexity of the case. Number 3, the level of skill and competence required of the representative in giving the services. Number 4, the amount of time the representative spent on the case. Number 5, results the representative achieved. Number 6, the levels of review to which the representative took the claim and at which level he or she became the representative. That was 6. And 7, the amount of fee requested for services provided, including any amount authorized or requested before, excluding any amount of expenses incurred. They go on to say that the SSA also considers the amount of benefits payable, if any, but authorizes the fee amount based on consideration of all the factors listed above. The amount of benefits payable in a claim is determined by specific rules unrelated to the representative's efforts. In addition, the amount of past due benefits may depend on the length of time that has elapsed since the claimant's effective date of entitlement. Okay, so that last part there, they consider the amount of benefits payable. This is important because I do believe, and very rarely do we have to do a fee petition. It's like, I'm pulling this out of my yang, but I think it's like 2% or something. It's just very rare. Nobody likes it. The representatives certainly don't like it. Even though the irony is you're not limited to that 7,200 we were talking about before, but it's a load of work to prepare. It's just a pain. And the SSA does not make it their priority to figure out what the fee is going to be. You could be sitting on it for 18 months and waiting. So, and then what's happening? Did they withhold it? Did they withhold some amount from the withheld back, if there were back benefits or not? I should emphasize that fee petitions also occur when there is back benefits, but if there was more than one representative on the claim, one that got the boot or withdrew but didn't waive fee, then everyone's got to submit a fee petition that was involved, and the SSA divvies up however they see fit. But the important thing to know, which was after number 7, about amounts of benefits payable, the SSA definitely considers if there was back benefits, and also, are you a person that's going to have $1,000 a month of Social Security disability, or is it SSI? I think they're going to really keep that fee very trim, because they're not trying, it would defeat the whole purpose, right? They don't want, the attorneys take the hit and the non-attorney reps take the hit, but that's just the nature of the beast here. I think if there is back benefits, they'll probably look at how much back benefits there were. If there's no back benefits, they will certainly be looking at what is the person going to be taking home that they're going to now have this big bill. If it's a $4,000 monthly amount, they might be more apt to give a more reasonable fee from the standpoint of the work performed. But a lot of the time, the fee petition produces an award that doesn't come close to covering the work done. But that, again, is the nature of the beast. Again, we don't prefer fee petitions. If the case, I would imagine if the case took 5 years and multiple hearings, yeah, then you're going to probably be seeing more than 7,200. And we do have a lot of those that go in multiple hearings. But in my experience, not a lot of fee petitions. And I'm very grateful because they're a train wreck. You wait forever, SSA loses it. It's just a disaster. But it's a necessary evil because you still need to get paid on some of these cases. Okay, so that's just what I wanted to go over about the fee petitions. We do have additional videos on how representatives officially before the SSA, that represent you in official capacity before the SSA, not just, consultative attorneys or anything like that, but when they're actually hooked with your case, what that's about, what they do, what some do, what some don't. And also, I think there's a video on when you want to get rid of your representative, things you should think about before you actually do it, because you might change your mind. All right, I will talk to you guys later. See you soon.